Hello, everybody. This is Samantha from the law offices of Samantha Wolfe, and I am here for our virtual seminar for this month. Today, we're talking a little bit about trust. So, today's title is Jack of All Trades, an Intro to Trust. And we do a lot of these virtual seminars to try to bring awareness to different topics that our clients might have questions on. And so we get a lot of questions about trust, so I'm happy to talk about that today. So let's do just some general basic information. So what is a trust? So a trust is a legal entity, a lot like a person or a business created by some legal document, and this document governs how assets titled in the name of the trust are to be managed. So it can hold title to assets like investments, to real estate. The trustee has the power to manage the contents of what's owned in the trust for the benefit of others. And the good news is, or the bad news, depending on how you look at it, is there are many different types of trust depending on what your purpose is and what you're trying to accomplish with the trust. So here's a list of the types of trust that we have. We have a revocable living trust, an irrevocable trust, testamentary trust, life insurance trust, charitable trust, and supplemental needs trust. And today I'm going to try to focus on the ones that we see most often in our office. So we might not cover all of these trusts, but don't you worry. We have plenty of videos that cover all of the trusts that we have on this list. So if you have questions about a trust that's on the list that I didn't go into, you can text, email, call our office, and I can give you a video specific to that type of trust. So let's talk about a revocable living trust. So a revocable living trust is one where the grantor serves as their own trustee. So the client sets up the trust, the client is the trustee, and the client can change the terms of the trust, add or remove assets from the trust. And the tax status of this type of trust is that it's a grantor trust. That means that it's still treated as owned by the grantor for income tax purposes and is still included in the grantor's estate for inheritance tax purposes and estate tax purposes. The good news there is the assets are still within the control of the grantor, so therefore when the grantor dies there is a stepped up basis in the value of the assets, and that's important for capital gains purposes. So subject to inheritance tax, but we get that stepped up basis. Revocable living trusts are most commonly used for probate avoidance. They're used to set up a plan for control or structure for beneficiaries or children after the death of the client. And usually the reason why we're setting it up that way is because we want to protect the assets for the children. We want to make sure that no creditors, divorce, car accidents, anyone like that, we want to make sure they cannot attach to the assets. The big upside of a revocable trust is that it provides lots of control to the client. They really aren't giving up any control at all with a revocable living trust, and it allows them to avoid the probate process. Big downside is the assets in a revocable living trust are still exposed to the client's creditors. So if they're trying to do asset protection or nursing home protective planning, then a revocable living trust isn't the type of trust that you want. A revocable trust, primary reason is probate avoidance. So probate is the official process where our executor gets appointed and administers the estate of the decedent. And it can be a little bit of hassle in Pennsylvania, and that's just because of the timing of what the state requires and how long it takes them to review things and get back to us. So sometimes we have clients that do want to avoid probate. Now, remember, you can avoid probate with beneficiary designations. So on retirement accounts, life insurance policies, if you have beneficiaries on those, that does avoid probate. You can also avoid probate with jointly titled assets. That would avoid probate too. So if I own a bank account with my sister and I pass away, my sister would avoid probate because title vests in her in that bank account. So the reason that people do the trust is that the assets, maybe you can't add a beneficiary. So for example, real estate, right now you can't add a beneficiary on. And so yes, you can add a joint owner, but there's a lot of risks there. So things like real estate, bank accounts, or personal property, we might put into a revocable trust because it avoids probate and we don't have the risks of having a child as a joint owner. Now, if everything is in trust and has a beneficiary designation, then the probate process can be skipped entirely when the decedent dies. We don't have to worry about anything going through probate. So when the first spouse dies, let's assume we have two spouses or a group of spouses, husband and wife, and one dies. So the surviving spouse could consider transferring all of the individually titled assets into the trust so that their estate does not need probated. We sometimes will have a survivor's trust where it holds 1/2 interest in the trust property that was owned in a joint revocable trust for both spouses. Sometimes we'll have a Clayton election, and that's where the surviving spouse or whoever the trustee is can elect to put assets in certain trusts depending on the tax ramifications and maximizing tax benefits. We typically have a qualified terminable interest property trust, and that's our Q-tip trust, and that's where the surviving spouse gets all the income at least annually and then can have access to the principal for health, education, maintenance, and support. And we do this type of planning with a revocable trust and a Q-tip and a family trust if we want to make sure that when one spouse dies, the other spouse can't redirect assets. Maybe there's a blended family, and so we want to make sure that things are locked in when one spouse dies. You might use a revocable trust that has a Q-tip and a family trust. It does help with taxes. Now, right now, our federal estate tax exemption is so high, but if that would ever drop, sometimes there's some tax benefits to having these types of trusts. You can minimize the taxes. We then usually have a family trust, which is a bypass trust, and that's where the surviving spouse can still be the beneficiary and have a limited power over the assets, but it allows the tax benefit because those assets are going to make sure that we're using the deceased spouse's federal exemption. And again, there wouldn't be any inheritance tax when the second spouse died. So again, this type of setup with a joint revocable trust and the Q-tip and the family trust and then having the Clayton election where you can fund either can be really helpful for inheritance tax purposes and for federal estate tax purposes. We just don't see as much federal estate tax planning right now because the exemption is so high. Now, we do use children's trusts at our office, and usually we're going to do them so that they're revocable while our client is living, and then when the client passes away and it goes to the children in trust, it becomes irrevocable. A lot of times our clients want restrictions or guidance past the age of 25, and that's important because you can name a custodian in your will up until 25, but if you want to provide guidance after 25, you have to do some sort of trust. So this type of children's trust allows you to name a successor trustee. You can permit the child to become a trustee at a certain age or distributions at certain ages. Like sometimes we might have 1/3 at 25, half at 30, and the remaining balance at 35. And you can give your child a limited power of appointment so that they can appoint it if they haven't used all of the assets. They can appoint it at their death to whomever they would want. So here's an example of a joint revocable living trust. So the top bubble represents the joint revocable trust, meaning while both spouses are living, it's a joint revocable trust. When one spouse dies, half of the assets drop down into the survivor's trust on the left, and the other half goes through the administrative trust where the Clayton election language is, and the surviving spouse can either choose to put assets in the Q-tip trust or the family trust. And then when the second spouse dies, it would go in trust for the children. And in this case, we don't have one children's trust, we have a trust per child. And we see a lot of clients choose that option because then the child can serve as their own trustee and can pull assets out of their own trust for whatever they would need. So this is a very common structure when we're doing a revocable living trust. Now, the opposite of a revocable trust is an irrevocable trust. But an irrevocable trust can be set up during life, which would be like a living trust. You're setting up while you're living. It's just an irrevocable trust. Or you can set it up at death. Either way you want to do it. It kind of depends on what assets you're protecting and who you want the protection for. And we always want to be mindful of those 4 Ds: divorce, debt, disability, and death. But with an irrevocable trust, you can protect your assets from creditors. And that would be like a nursing home would be one big creditor that we think of. So assets that clients might want to protect would be their home, their rental real estate, their non-rental real estate. They want to protect their IRAs, but we're going to talk about how you can't transfer your IRAs typically into the trust because it's going to trigger all the deferred tax that you've had. So usually we don't recommend that. Sometimes clients are wanting to protect their IRAs. Life insurance, you can protect the cash value to make sure that you're maximizing the death benefit to your beneficiaries, and so you might transfer life insurance into the trust. You can transfer bank accounts, business interests, collectibles, future inheritance can go into trust if you want to protect. Whenever we're talking about an irrevocable trust, one of the things that we want to think through would be the three possible options about who pays the income tax that would be generated by the assets owned in the irrevocable trust. So the trust can pay it, the beneficiary can pay it, or the grantor can pay it. And the important thing to remember is that there's no double taxation, but there might be different types of taxes that apply to different people. So two main types of trust from a tax status standpoint, we have a grantor trust and we have a non-grantor trust. And a grantor trust means that the grantor pays the tax on the assets in the trust because the grantor retained so much control and power over the assets in the trust that it's considered theirs for income tax purposes. So a lot of ways that we do that is that there can be a reversionary interest in the trust where anything worth greater than 5% of the value of the trust. If that's the case, then it would be considered a grantor trust. It can be where the grantor retains the power of disposition as long as that's held by the grantor or by a non-adverse party. Now, if we have a definite standard, meaning that the trustee is making it for health, education, maintenance, and support, then the grantor doesn't have the power of distribution. Or if we have separate trust shares created for the beneficiaries, we can make it so it's a non-grantor trust. But normally, if the grantor retains the power of disposition, then it's a grantor trust for income tax purposes. And then the last way that we see most of our clients make it a grantor trust is the power to add beneficiaries. That's what we use a lot in our trusts. And this is considered an incomplete gift. So assets are included in the estate, but that means that they do get a stepped up basis when the grantor passes away. If the beneficiary retains the power to add other beneficiaries, then if they exercise that, it might be deemed a gift. And if the trustee has the power to add beneficiaries, then it might create some fiduciary issues. So most of the time we have it so that the grantor has the power to add beneficiaries. Now you can have a non-grantor trust, and that a non-grantor trust is where the beneficiary or the trust itself pays the tax on the assets. So you can do a non-grantor trust. Tax status wise, it means you need an EIN, you're filing a separate return, and it's subject to the trust income tax rates. So you want to make sure you're doing that. This slide explains why, because we have individual versus trust tax rates. Individuals are in the 35% bracket when they earn $231,000 or more, roughly, but not over $640,000 of taxable income. However, trusts are in the 37% bracket when they earn about $16,000 of taxable income. For individuals, you aren't in the 37% bracket until you have $640,000. So it's a big deal when you think about the fact that if you have a non-grantor trust, same tax rates as we have as individuals, but you're going to get to the highest bracket if the assets in the trust generate $16,000 of income or more. The next thing you want to consider with a trust is whether or not it's a completed gift for federal gift tax purposes. And the way that you're going to make that determination is you have to ask if there's a lack of consideration. So if I'm buying something and I'm paying fair market value, then it's not considered a gift to me. However, if someone is transferring something to me and I'm not paying any consideration, or I'm not paying the fair market value consideration, then it would be considered a gift, as long as the donor, the person who's giving it to me, has given up their right of dominion and control. So that's why we have those two bullet points there, because there has to be lack of consideration and a loss of dominion and control. Now, whenever a gift is made, assuming that there was no consideration and the grantor gave up their ability to control the assets, then that means that the recipient gets carryover basis. So the example to that would be if real estate purchased by the grantor was $10,000 and at fair market value it's actually it's worth $100,000, then there would be $90,000 of gain there, potentially subject to capital gains if that real estate would be sold. That's carryover basis. That's where someone gave me the property and my basis then becomes the $10,000. So if I sell it, I have $90,000 worth of gain that I'm going to pay at a rate of 15% if that's my capital gains rate. The stepped up basis is where I wasn't given the property while the donor was living. Maybe I inherited it at the donor's death. And if so, then the fair market value of $100,000 becomes my basis. So rather than having to pay all that capital gains, instead I get a stepped up basis. So I would have paid 4.5% inheritance tax on the 100,000, but then I avoid the capital gains, which would be 15% of 90,000. So if no Pennsylvania inheritance tax, then we have to worry about the carryover basis. So, but if we do pay Pennsylvania inheritance tax, and that's a rate of 4.5 for lineal descendants, then typically we're going to pay a much lower tax rate because we get that stepped up basis. And remember, the current federal exemption in 2026 is $15 million if you're single and $30 million for a married couple. A lot of the irrevocable trusts that we use at our office are intentionally defective grantor trusts. That means that it's an irrevocable trust where we've made a completed gift for federal gift tax purposes, so it's not included in the client's estate for federal estate tax purposes, but the client has retained enough control over the assets that it's still considered theirs for income tax purposes. And in order to accomplish that, we have to have the grantor retaining certain powers, and that could be the power to add charitable beneficiaries under Internal Revenue Code Section 674, could be the power to make loans to the grantor without adequate consideration under Internal Revenue Code Section 675-2, the power to substitute assets of equivalent value, Internal Revenue Code Section 675-4, and then the power to use income to pay premiums on the insurance on the life of the grantor or the grantor's spouse. That would be 677A3. Any of those powers, if the grantor has that power, then it's enough power for it to be considered theirs for income tax purposes. Now, when we do trust to protect against nursing home costs, we typically do income-only protector trusts, and that's to protect against long-term care. And in this case, that means the trust is irrevocable, but the grantor can be the trustee, which means they can buy and sell assets, they can invest the assets, they can add and remove beneficiaries. So it's still considered theirs for income tax purposes. So it's a grantor trust. It's irrevocable, but it's a grantor trust. And we even allow the grantor to be the income beneficiary, but not the principal beneficiary of the trust. And they can add and remove the beneficiaries at any point in time. What we do is we take the power of distribution that normally the trustee has, and we give it to a position that we call the trust protector. Trust protector's job is to distribute assets out of the trust to the beneficiaries, and only the trust protector can do that. And if that's the case and the client is not serving as the trust protector, then we get the nursing home care, protection care there with this type of trust. Now, it's important to know that there is a 5-year look back period, so the assets have to be owned in the trust for 5 years before they're protected. Okay, and we like these trusts at our office. We use them a lot. And here's an example of the type of trust that we use. So if we have John and Jane Doe and they set up a joint trust, we have this income-only trust, and we might do 2 because maybe they have 2 parcels of real estate, and we set them up, but John and Jane can serve as the trustee, so that means they can buy, sell, choose how to invest it. If it's real estate, they can sell it, buy a new property. So it gives the client a lot of flexibility. They don't have the power of distribution. We have to give that to the trust protector, who we've made the children in this case. And that's what gives us the ability to protect the assets. Now, again, the assets do have to be owned in the trust for 5 years or longer. Now, the client, the grantor, can serve as the income beneficiary, but we want to make sure the principal beneficiary would be children or whoever the client's choosing. And again, in this picture, it's showing that when the second spouse dies, it goes in trust for each child so that the child has creditor protection. Let's talk about a testamentary trust. So a testamentary trust is one that is not created while the client is living. It's usually created under a last will and testament or some other written instrument, and it's created at the death of the client. So the trust isn't being created during their life. They're not funding it during life. Usually it's created under the will, and the will would say, upon my death, I want these assets to pay in trust. And that's what we call a testamentary trust. So we use these a lot if the client has concerns about the irresponsibility of a beneficiary or the trustworthiness of them to be able to serve. And in our wills, we always do give the executor or the personal representative the ability to create a supplemental needs trust. And that supplemental needs trust would be a testamentary trust, because we don't know what the future might hold for some of our beneficiaries, and that allows us to be able to protect assets. We can also use irrevocable life insurance trusts. We call them ILITs, and they can be funded with assets like life insurance policies. The life insurance policy would be owned by the trust, and the reason that we do that is then the death benefit of the life insurance is not included in the decedent's value for federal estate tax purposes. So we're more worried about this in the situation where the federal exemption was lower. We can use charitable remainder trust. This is a trust that would provide income to the donor or to our client or any other beneficiary for their life or a certain term of years. And then when that individual died or when that term of years is done, then it pays to the charity. The benefits is that we get a tax deduction for it based on the remainder value, but the donor can still receive that stream of income. It does allow capital gains deferral because selling appreciated assets inside the trust avoids immediate capital gains. An example would be if a donor transfers appreciated stock into a charitable remainder trust, sells it tax-free, and then uses the proceeds to provide a lifetime income while leaving the remainder to charity. A charitable lead trust is the opposite of a remainder trust. So a charitable lead trust is a trust that provides income to the charity at the offset or at the beginning of the trust term. And then after the term ends, the remaining assets are going to go to either the client or to the beneficiaries that they've listed in the trust. The benefit of a charitable lead trust is we get some income tax benefits there. So that's always nice. And it can be structured as a grantor or a non-grantor trust depending on what you're trying to accomplish with the trust. Charitable lead trust is going to be ideal for high net worth clients seeking to support charities while also preserving their wealth. We're seeing more and more charitable trusts, which I always love getting to do charitable trusts. We're seeing more of those come about. And I hope we can continue to see that trend because I think they're fun trusts to use and they're very effective. Okay, the next type of trust we're going to talk about is a supplemental needs trust. And the purpose of this type of trust is to be able to provide financial assistance to someone on government benefits without disqualifying them for the government benefit that they've already qualified for. The special language is that we have to say that the trustee can supplement but not supplant whatever services the beneficiary may from time to time be eligible to receive. So for example, if we have a beneficiary who qualifies for SSI, then the trustee of the S&T can't make distributions for food or shelter. My favorite type of supplemental needs trust or special needs trust is the third party S&T, and that's where the grantor is usually the parent or the grandparent, and it's commonly funded through the will or through life insurance policies. But the beauty of a third party S&T is there's no payback provision. So when the beneficiary passes away, the client gets to say this is where any remaining assets are going to pay. It doesn't automatically go back to the state. Third-party S&T can either be initially drafted as a revocable or as an irrevocable trust, which offers a lot of flexibility. Now, there usually are rules about access to the funds or disbursements from the trust. So you want to make sure you're thinking through that and you're familiar with what benefit your client or the beneficiary of the S&T is going to be eligible for. We do have first party S&Ts, and that can be created by parents, grandparents, the guardian, the court, or the beneficiary themselves can create a first party S&T. It's filled with assets that the beneficiary was entitled to. So it could be a settlement from like a car accident, but these are going to be assets of the beneficiary. The beneficiary was entitled to these assets. The first party S&T must be approved by the Department of Human Services. When we say Department of Public Welfare, we mean Department of Human Services. And we then also do send it to the state S&T fund so that they're on record as well. So first party S&T is typically created by the parent, the grandparent, the guardian, or the court, or it can be the person who has special needs. They can also create a first party S&T. The assets are the beneficiary's assets. Now, this type of trust must be approved by the Pennsylvania Department of Human Services, the Office of General Counsel, and we typically then send it to the S&T depository to make sure they have a copy as well. It does have to be an irrevocable trust, and a first party trust has to have a payback provision, which means that it says that passes away, that to the extent that any benefits have been paid on behalf of that beneficiary, then it goes back to the state. So that's why first party trust can be very powerful, but that's why I prefer a third party trust if we can do it, is because a first party has a payback provision. Now, you can create an S&T and put assets into it. So for example, a car accident settlement can go into a first party S&T. That's because it's an asset of the beneficiary. We just want to make sure the trust is created so that the settlement can pay directly into the trust. So that's one type of an S&T. And then we also have a pooled supplemental needs trust, and that's established by the beneficiary, by the family member, by a guardian. It's administered by a nonprofit. So for example, Achieva is one that we've used, and it has pooled management. So we don't do a lot of pooled S&T trust. Normally we try to do either a first party or a third party, but this is a way that you can prepare an S&T as well. Okay, I hope this was helpful. This was a fun session where we just did a crash course in the different types of trusts. If you want more in-depth information about a type of trust, you can always text or call us, because we can send you a specific link to that particular type of trust if you have questions about it. You can always reach out to our office. We're located at 20 East 6th Street in Suite 206 in Waynesboro, and you can call us at 717-655-2676 to schedule an initial consultation. Thank you so much for joining us today for this trades, talking about the different types of trusts. I hope it was helpful. Thank you so much for joining us. Check out our YouTube channel if you want to check out other videos. Thanks, everybody.